Hello, Kelly Blatnik with Blatnik Law here to discuss Nevada marital property. In the state of Nevada, marital property is considered community property. Essentially, anything acquired during the course of the marriage is owned by both parties in the entirety, which means that no one party is able to encumber, gift, give away, or dispose of marital community property. Important exceptions from the marital community property include anything that was inherited from one spouse or property that was owned prior to the marriage. A couple examples are, let's presume that Anne owned a rental property prior to the marriage. Anne marries Jan. Jan is not entitled to the proceeds from that rental property or distribution of that rental property upon a dissolution because Anne owned that rental property prior to. Now, if Anne and Jan married and then Anne bought the rental property with an inheritance from Aunt Sue, that rental property would still only belong to Anne because it was considered an inheritance, so long as there's no commingling of funds. So I'm just discussing our basic principles. There are always exceptions in the law to just about everything. So when you think of community property or marital property in the state of Nevada, anything that's acquired during the course of the marriage, unless it's an inheritance or from a personal injury matter or previously owned, it is community property and may be looked at by the court when there is a distribution of property upon the dissolution of the marriage. That's why it's always important to discuss prior to filing with an attorney what the entirety of the marital estate is and whether or not any funds were potentially commingled that would make separate property marital property, and be sure that you understand what's going to happen when the marital estate is indeed divided by the spouses.